who are watching the recording, just, welcome again. I know that you're at training number 2 or 3 or 4 of training number 3 of a series of fair housing trainings. So some of this is reviews, some of it may be new. The focus of this training obviously is compliance, but I hope that some of the information also will be helpful as far as information for your constituents and residents about their fair housing rights as well. We have, as I said before, a lot of variety, a number of different fair housing topics that affect you both in your capacity as a municipality covered as a housing provider under the Fair Housing Act, and also serving a constituency of consumers. So we're going to talk just kind of review for many of you of the Fair Housing Act, go into a little bit more detail about disability issues, which is where a lot of the complexity comes in, regarding kind of technicalities, gray areas under the law, and where people have a lot of questions. We're going to talk a little bit about design and construction requirements under the Fair Housing Act. I think we'll take a break then and do kind of the more local government specific topics, so zoning and land use, nuisance and crime-free housing ordinances, catch-all of other fair housing considerations for local governments, things like code enforcement, and talk a little bit about the bind that you all are sometimes in as far as protecting the free speech rights of your constituents versus fair housing rights of your residents, which for you as a municipality is often a particular sticky area in as far as how those two sets of laws interact. Then we're going to talk a little bit, I think we'll take another break there and talk about some more recent HUD guidance and program rules. Some of those things are going to apply to housing providers in your municipality. Some of them are going to apply in situations where HUD funding is involved particularly. And then we're going to talk about affirmatively furthering fair housing, both that obligation as it exists under the Fair Housing Act, recent changes, some of the regulations around affirmatively furthering fair housing are in a little bit of limbo right now. So we'll talk about just current status of that and where we stand now as far as affirmatively furthering fair housing. So first up, just basic Fair Housing Act review. When we talk about fair housing, I always tell consumers fair housing is a really vague term. There are lots of things in housing that may be fair or unfair, but when we talk about fair housing, we're talking specifically about the federal law that protects people from discrimination in housing-related transactions. And the Fair Housing Act is kind of the common term for the Civil Rights Act of 1956. This law was passed just, 51 years ago, as of a couple weeks ago, on April 11th, 1968. It was passed a week following the assassination of Dr. Martin Luther King Jr., and the original law, as enacted in 1968, protected consumers from discrimination in housing-related transaction based on 4 protected classes, so race, color, national origin, and religion. The law has been amended twice, once in 1974 to prohibit sex discrimination in housing, and again in 1988 to outlaw discrimination based on both disability and familial status. And the 1988 amendments had, yes? Yes, familial status has a really specific definition under the Fair Housing Act. It refers specifically to the presence of children in the home, children under the age of 18. So under the Fair Housing Act, families are protected when they contain children under the age of 18 or pregnant women or anybody in the process of securing custody of a child. So, you know, foster children would be covered under that. And familial status in the Fair Housing Act doesn't refer to marital status, doesn't refer to any other type of familial, family configuration except for the presence of children. So it's a very narrow definition. So in addition to the additional two protected classes of disability and familial status, the 1988 amendments added an administrative enforcement mechanism to the law. So prior to 1988, if somebody felt that they were discriminated against in housing, their only means of redress was to hire a lawyer and file a lawsuit. So the 1988 amendments added an administrative complaint process, primarily through HUD's Office of Fair Housing and Equal Opportunity. It's a, free process for complainants to file a fair housing complaint. If it's a consumer who feels like they've been discriminating, it just kind of, added an enforcement mechanism that was more accessible to people who were seeking a remedy under this law. There are a few other government entities that handle discrimination cases. The Department of Justice takes fair housing cases in more systemic situations, so not an individual consumer feeling like they've been discriminated, but more than one complainant who's experienced discrimination by the same housing provider would be a case that the Department of Justice would handle. Yes?
So, but HUD doesn't proactively go out, like unless somebody files a complaint, they don't proactively go out.
So the question was whether HUD initiates complaints itself or whether it responds to complaints from consumers only. HUD is permitted to do what are called secretary-initiated complaints. So the secretary of HUD can file complaints and investigate and adjudicate complaints on behalf of the U.S. government. And an example of that would be, you may have read recently about Facebook, the Facebook being determined to have been engaged in discriminatory advertising because they allowed advertisers placing ads to narrow down based on audience in ways that were discriminatory. So that would be an example. That particular complaint was a secretary-initiated complaint, which means HUD itself filed that complaint against Facebook. So. Right, right.
Requiring them to go before the zoning hearing board, and the residents are saying it's going to devalue their property.
Right.
And they're requiring all this stuff that, we've been instructed is plainly not legal.
Right, right.
But nothing's happened. So then
Yes.
Our residents see, well, they can do it, so don't tell me you can't do it here.
Right, right. Yeah, so that is an issue under the Fair Housing Act. The question was about seeing other municipalities engage in behavior that, Whitehall Township understands to be discriminatory, and that being a problem with residents believing that those other municipalities are doing this. And, you know, unfortunately, it is the situation that in most cases, you know, for those situations to be remedied, somebody is going to have to file a complaint.
I think you just did. You just may have mentioned that.
Right.
I would consider that a complaint.
Right. I mean, somebody actually has to go through filing the formal complaint, and somebody who's harmed by that action. So under the Fair Housing Act, somebody who's filing a complaint has to have standing. So they have to be personally damaged by whatever the conduct is. People who realize they've been discriminated against sometimes do and sometimes don't file complaints for a variety of reasons. I mean, as an organization, we're certainly aware of a lot of discriminatory conduct by municipalities. I mean, our organization covers a seven county area, and we've chosen to address that through education rather than through filing complaints, because it is such, yeah. Right. In most cases. You know, secretary-initiated complaints are relatively rare, and they're usually those really high-profile types of cases, like in the case of Facebook. So, you know, again, HUD sort of the primary, the primary entity that takes administrative complaints, and there are a couple of state-level government entities that do as well, similar to DOJ. The state AG's office deals with more systemic types of fair housing complaints, and the Pennsylvania Human Relations Commission deals with individual complaints under the state's human relations law. So similar to, this slide is just kind of a restatement of the basic protected classes under the law. Again, race, religion, national origin, sex, disability, and familial status, with the specific definition of familial status applying to families with children. And the Fair Housing Act enumerates sort of a set of prohibited activities. Obviously, refusal to rent or sell housing to somebody based on protected class status, refuse to negotiate for housing. So, situations where a consumer, because of their disability status, race or familial status or other protected class, kind of can't even get into the door in order to have a conversation about housing. Make housing unavailable or deny housing as available. This is kind of the catch-all of the law. I think the language used in the Fair Housing Act is something like otherwise make unavailable or deny, and that covers zoning and land use, code enforcement, homeowners insurance, mortgage lending, all the different other types of transactions that affect people's access to housing but aren't what you think about as traditional housing transactions, rental or sales. Setting different terms, conditions, or privileges for the sale or rental of housing or any other type of housing-related transaction, again, based on protected class status. Discriminatory advertising, and also threatening, coercing, or intimidating anyone for exercising their fair housing rights or pursuing remedy under the Fair Housing Act is also prohibited by the law. Covered transactions, as I said, includes both rental and sales transactions and housing-related financial transactions, things like mortgage lending, including refinances, home equity lending, homeowners insurance, rental insurance, and then appraisals as well, all of those types of financial transactions that affect people's ability to buy a home. And then various municipal policies, so zoning and land use in particular, but also a variety of other policies on the municipal level that affect access to housing. Covered dwellings, again, the Fair Housing Act has been interpreted pretty broadly to cover both traditional types of housing, rental and sales housing, both public and private housing, mobile home parks, and then also things like college dormitories, homeless shelters in situations typically where it's not like a one-night emergency shelter, nursing homes, group homes for people with disabilities. So a whole variety of various dwellings under the Fair Housing Act. So I'm not going to read this slide, but this is the basically everyone slide, just the variety of people who affect access to housing that must abide by fair housing laws. So obviously real estate agents, landlords, but also architects, developers, homeowners associations, elected officials, quite a variety, municipal employees, quite a variety of individuals who affect access to housing. And the penalties for violating the Fair Housing Act, as I said before, consumers who feel like they've been discriminated against have the choice of filing either an administrative complaint of some sort or a federal lawsuit. And associated with penalties for violating the Fair Housing Act, that consumers can be reimbursed both economic and non-economic damages, so real costs that are associated with an act of discrimination, but also things like humiliation, emotional damages. Punitive damages and civil penalties, which are essentially, punitive damages being additional damages that are designed to punish a respondent in cases usually where it's an egregious or willful act of discrimination, civil penalties being essentially fines. Usually as part of agreements, there's some type of monitoring of an entity that enters into an agreement. And fair housing cases are fee shifting, which means a prevailing complainant in a fair housing case, usually the respondent is going to be responsible to pay the attorney's fees of the complainant. Injunctions are, an example would be in a situation where a landlord has engaged in particularly willful discrimination. An injunction might be that landlord is prohibited from interacting directly with tenants or prospective tenants. DOJ has settled a number of sexual harassment in housing cases recently, and usually there's an injunction prohibiting that perpetrator from interacting directly with residents. And then for subsidized providers who use tax credit financing, loss of tax credits can be a penalty. So I'm going to talk a little bit about kind of theories of discrimination under the Fair Housing Act, and this gets a little legalistic, but I think this is important, particularly for municipalities, to be able to be aware of and to think through the effects that various policies may have that may unintentionally affect protected class members. So discriminatory treatment under the Fair Housing Act is pretty easy to understand. It's different treatment based on a protected class. So something like, outright discrimination in municipal services, different terms and conditions based on protected class status, refusing to make reasonable accommodations and modifications, which we'll discuss in a lot of detail later. Inquiries into the nature or severity of a resident's disability, and harassment or intimidation would all fall under those categories of discriminatory treatment, which is, basically, again, treating somebody differently because of their membership in a protected class. But under the Fair Housing Act, policies that are facially neutral and not intended to discriminate can also be determined to be violations of the Fair Housing Act. So this is policies or practices or rules that have a disproportionate impact on one member of a protected class versus somebody else, even in situations where there wasn't the intention to discriminate. And I'm going to kind of go through for a provider or a respondent to have determined to violate the Fair Housing Act. Under this disparate impact theory, there's a 3-step process to proving that liability under the Fair Housing Act. And I always like to use an example from about 15 to 20 years ago. All of the big homeowners insurance companies were sued for race discrimination. So, Allstate, Prudential, State Farm, all of the big companies had fair housing cases filed against them. And part of the reason behind these fair housing lawsuits was that the insurance companies had a variety of facially neutral policies, so policies that didn't have anything to do specifically with race, but in their underwriting guidelines, the insurance companies wouldn't write policies that had, for properties that had flat roofs, wouldn't write policies for houses that were over a certain age, houses that were younger, or houses that were under, over a certain age, under a certain market value. And these were all policies that, didn't have a discriminatory intent and didn't blatantly or explicitly mention a protected class. But when you look at older cities nationwide, that the policies were having the effect of excluding various cities or neighborhoods based on the race of the residents that lived there. So in order to kind of prove that something has been a Fair Housing Act violation under this disparate impact theory, there are 3 steps, and the burden for proof under each of these steps shifts from the complainant to the respondent. So the first step is for a complainant to prove that this policy had a disparate impact on membership on a protected class. So in this case, usually it's some kind of statistical analysis about who's affected by this policy versus who's not affected by this policy. So in this case, due to the types of houses that these underwriting guidelines were excluding, the plaintiffs in these series of cases were able to show that this did have a discriminatory effect based on race. So then the second step, the burden shifts to the respondent to prove that there was actually a non-discriminatory business interest for having this type of policy. And in this case, there was, the insurance companies were able to say that, these factors do have some effect on risk. Their intention was to minimize their own risk. And then the third stage is for the complainant to be able to prove that a less discriminatory rule would have served the same legitimate business interest while being less discriminatory. So in this case, the plaintiffs in these cases were able to articulate alternate types of policies, alternate types of underwriting guidelines that could have minimized the risk that the insurance companies were trying to accomplish, but do it in a way that it didn't have this disparate impact based on the race of the residents. So does anybody have any questions about that? I know this particular issue is kind of a lot. But when we talk a little bit more about zoning, we'll talk about how, about disparate impact a little bit more. So I'm going to just not spend too much time, but just make you aware of some other laws that in some cases provide additional protections that are not provided by the Fair Housing Act, just to kind of make you aware that there are situations that may not be covered by the Fair Housing Act, but there may be other laws that apply. So one of these laws is the Civil Rights Act of 1866. This was a post-Civil War Reconstruction era law that that is still in effect, and occasionally complaints are still brought under this law. So basically, this law says, excuse me, that any person born in the United States, regardless of their race, has an equal right to enter into contracts. And this includes real estate-related, housing-related contracts. So we'll talk in a little bit about exemptions under the Fair Housing Act, certain types of housing that's not required to comply. The Civil Rights Act of 1866 doesn't have any exemptions. So when I talk about exemptions to the law, race is not going to be exempt because it's covered by this other law. So the Pennsylvania Human Relations Act is kind of the state version of the Fair Housing Act. In a lot of ways, it has similar protections to the Fair Housing Act, but it also has a couple of additional protected classes. One of those is age, and the state of Pennsylvania defines age as being over 40. So basically, if you're in Pennsylvania, you're protected if you're under the age of 18 under the Fair Housing Act, over the age of 40 under the Human Relations Act. We get complaints in our office usually from young adults, 18, 20, 22-year-olds who say that somebody won't rent to them because of their age, and in the state of Pennsylvania that may be discriminatory, but it's not illegal because Pennsylvania describes age as only over 40. And then also Pennsylvania protects users, handlers, or trainers of assistance animals for people with disabilities. So somebody who trains guide dogs or something like that would be protected.
So is this the relevant act that results in people saying, gee, I can't be discriminated against because I'm training a pig to be somebody's companion pig?
Right. So I'm going to talk a little bit more in detail about assistance animals later. The protections for people with disabilities who use assistance animals under the Fair Housing Act, and then also the Pennsylvania Human Relations Act kind of expands that. But I know that's kind of a particular hot topic. It also arises in zoning cases. So I'm going to talk in a little bit more specifics about that issue. Pennsylvania has also passed some more recent legislation around that. So I'll kind of get into that a little later. There are always often lots of questions about that topic because it's an area where there's definitely non-compliance by housing providers, but there's also abuse by consumers as well.
Can I ask one other question that doesn't go to anything you've covered so far, but
Mm-hmm.
In terms of who must be here for this training,
Okay.
what is the determination that mandates us to have somebody in this room?
Right.
Speaking specifically of our recreation director.
Okay, so questions about, the question was about why somebody in particular has to be in this room. That's a HUD question because it's going to be, it's going to be determined by them under your agreement with HUD.
Okay. Do we need a recreation director?
He's shaking his head no.
Well, I know that.
The way it's drafted, it's anyone in the township, I don't have it in front of me, that has any involvement in, land use, development, housing, things like that. So, it's difficult. I believe the reason he's here is because in the past, the recreation director has been included. And the list was approved by, we've gone through, I think, 3 different HUD consultants.
Mm-hmm.
They turn over a lot.
Right.
The first year we did training, it was recommended by that consultant. We do have a different consultant now, so. Lisa has in the recreational programs that he provides, or the township provides to the recreation department.
Okay, so.
Yeah, so that would be a HUD question.
There was a real justification for him having to be here, so you lose.
No, he wanted to hear me play the clarinet.
My polls don't fit this.
And then in addition to the state law, there are an increasing number of municipalities now in the state that do have their own human relations ordinances that protect additional protected classes. So there are, 45, this is probably out of date at this point, but at least 45 municipalities that do have additional protected classes. Usually those are sexual orientation and or gender identity and sometimes lawful source of income. So it's, this doesn't necessarily apply to you specifically because obviously you're only dealing with your own municipality. But, for anybody who's dealing with multiple jurisdictions, it's just important to know what the local laws are in addition. So the additional laws here that prohibit discrimination in programs that receive federal funding. So Civil Rights Act of 1964 also prohibits discrimination based on race, color, and national origin in any program, housing related or otherwise, that receives federal funding. That might be the one, Parks and Recreation, maybe you receive CDBG funding, and that would be the applicability for other types of programs and services that the municipality has. Section 504 similarly prohibits discrimination based on disability in programs or activities receiving federal funding. And then the ADA prohibits discrimination, again, based on disability in any programs or activities or services provided by local government. Also a variety of other areas, public accommodations and so forth. So just to be aware that these other laws do exist to provide protections beyond the Fair Housing Act. So I'm going to talk a little bit about what the Fair Housing Act does not prohibit, because I think it's important to recognize that the Fair Housing Act deals specifically with treating groups of people differently based on whether they're a member of one of those protected classes. But the Fair Housing Act doesn't guarantee anyone the right to housing or financial housing-related transactions that they can't afford. So somebody has to be able to afford whatever the housing, whatever the loan product is that, that they're seeking to gain access to. Property owners, whether they be landlords, whether they be owners who are selling property, can set rents or sale prices at whatever the market will bear. So we're not in a place where we have any kind of rent control. Landlords, home sellers can set the price at essentially whatever they want. Agents or property owners can refuse to rent to people when they have reliable information that the person has a recent history of violent, disruptive, or destructive behavior. When we get to talking about disabilities, sometimes when any type of disruptive or violent behavior is disability related, maybe related to a mental health disability, there is a little additional obligation of the landlord to give that person a chance to put into place supports that would, minimize or eliminate those behaviors. But in general, the Fair Housing Act doesn't require anybody to rent to anyone who's going to be a danger to other residents or property. Yes. Hoarding is a good example of how this can, how this issue of not being required to rent to people who may cause property damage can get more complicated when it's a situation with a disability, since usually hoarding related behaviors are disability related, that typically a housing provider is not going to be required to have, dangerous hoarding behavior that's violating property maintenance codes or any type of health and safety regulations. You're not going to be required to just let that continue, but we'll talk more about reasonable accommodations later, but that would be the example of where somebody with a disability, because the hoarding's related to a mental health condition, would have the right to request like additional time to get the hoarding situation under control. I mean, in that case, it would be considered reasonable for them to request an extra period of time to ameliorate that situation and then get re-inspected or something like that. But then if they're unable to, to bring a unit into a safe condition, then that would be a case where the Fair Housing Act would no longer protect them if the municipality or the landlord has attempted to work with them through the reasonable accommodation process, has documented their attempts to do so, and that individual just can't bring that property up to an appropriate, safe condition. Then you're going to have to implement whatever procedure or consequence would happen in the case of that type of violation. So an agent or property owner can adopt and apply any types of non-discriminatory criteria regarding income, creditworthiness, as long as it's being applied to everybody across the board, they can implement whatever qualification criteria they feel is appropriate. An agent or property owner is never required to rent to current users and dealers of illegal drugs. We'll talk again, just anticipating another possible question, the question of addiction recovery homes. We'll talk about that in the zoning section, but the Fair Housing Act does not protect current users of illegal substances. And in Pennsylvania, landlords can choose not to rent to voucher holders unless they're in a municipality that specifically has source of income protections and includes receipt of housing subsidies in that protection. So in Pennsylvania, typically a landlord can say they're not going to rent to voucher holders.
A voucher holder is somebody that would get a subsidy for renting.
Right.
How is that not discriminating?
There are a lot of people that do argue that is discrimination. But what's been determined, there was actually a recent case in Pittsburgh. Pittsburgh and Philadelphia both have source of income protection. So they say a landlord can't restrict income to just employment, like they have to accept child support or public assistance or any other type of lawful income, including in the cases of these two cities' laws, receiving a voucher. And recently in Pittsburgh, there was a decision that said because taking a Section 8 voucher is more burdensome on a landlord in terms of additional inspections and so forth, that they couldn't require landlords to accept Section 8. But obviously on the other side, there are a lot of people who do say that usually receiving some kind of subsidy or some kind of non-income, non-employment income is almost always associated with a protected class. So, child support, disability, Social Security, various types of public assistance are almost always effectively associated with a protected class. So, there's certainly a lot of people who do make that argument.
Like Whitehall, there's apartments on the north end, south end that are subsidized. And
Right.
I always consider that's fair housing.
Right.
And fair housing is more of concentration, like
Mm-hmm.
what they would call a project.
Right. Yeah, so that's definitely a debate over that particular issue. And there's some states that do include source of income under their state laws. Pennsylvania isn't one of them. I think there may be 20 states at this point that consider that to be a protected class under their state law. So exemptions under the Fair Housing Act, there are a number of exemptions where some types of housing providers don't have to comply with certain parts of the law. One of these is called Mrs. Murphy's exemption, and you kind of imagine elderly Mrs. Murphy renting out a unit in her home. At the federal level, this covers owner-occupied buildings that contain 4 or fewer units when the owner doesn't use the services of any type of real estate professional. And in Pennsylvania, this is another area where the laws differ a little bit. Pennsylvania is more restrictive and says the Mrs. Murphy's exemption only applies when there are two units. So Mrs. Murphy, who lives in one unit in her home, rents out another unit, doesn't have to comply with the Fair Housing Act, with the exception of she's not allowed to make discriminatory statements because that's never That's never allowed under the Fair Housing Act. There are no exemptions to advertising. So Mrs. Murphy basically has to say, like, I'll take your application and let you know. But if she doesn't want to rent to, you know, a family with children or whatever, she doesn't have to do so. Similarly, for sale by owner, there's another kind of narrow exemption for owners who own small numbers of single-family homes and don't use the services of a housing provider. So since real estate agents, whether they're serving as a broker or a property manager, are never permitted to violate the Fair Housing Act, using an agent always throws out these exemptions. Housing occupied or operated by religious organizations or clubs are permitted to restrict occupancy in the housing that they operate only to members. However, the caveat to that is they can't discriminate in membership to, you know, based on the other protected classes. So if there's a religion that allows anybody to be a part of that religion, regardless of their race or familial status or disability, and they operate housing, then they can restrict the housing only to their members. Housing for older persons is basically the exemption that allows senior housing. So there are two categories of housing for older persons. Either 80% of the units need to be occupied by at least one person over the age of 55, or all of the residents have to be over the age of 62. And if they meet these thresholds, and if they kind of constantly monitor their resident population to ensure they stay within these guidelines, they can discriminate against families with children. They can, you know, decide not to permit children in their housing. And then again, there's never any exemption for discriminatory statements or advertising. Under the Fair Housing Act, verbal statements are considered to fall under advertising, and so there's never any exemption for advertising. So I'm going to go into a little bit more detail about a couple different issues under the Fair Housing Act, a couple of different protected classes. Then I'm going to talk more specifically about disability, since that's the really, really complicated area. So under the advertising guidelines of the Fair Housing Act, you can't, or housing providers can't ever publish or make statements that express any type of preference based on protected class membership. And in general, advertisement should describe the property, the amenities, features of the property, and not the potential occupants. You know, we see, and I'll, you know, I'll give some examples. These are still all over Craigslist. You know, despite this prohibition on discriminatory advertising. This is really similar to the situation that was brought up earlier about, you know, having pretty blatant acts of discrimination out there, but unless somebody files a complaint, it sort of gives people the impression that this is acceptable. So we see a lot of these, especially around families with children, where they're expressing preferences for a particular type of resident.
So
And
these ads relate to rentals that don't meet the standard of less than 4 or less than 2.
right.
So this is for larger.
Yeah, but even since advertising is never exempt, even if there's somebody who does meet that Mrs. Murphy's exemption for owner-occupied small housing, they're still not allowed to advertise in a discriminatory way.
So they can discriminate without the mature adults in the first line. If a younger person comes, they can say, "No,
Right.
you're out."
Well, they basically have to say, because statements are still considered advertising, so they can't say anything discriminatory, and this is it's kind of a tricky situation, is they just have to say, show the unit, take an application from the person, and say, I'll let you know whether you're approved or not. And then they can then not approve that person if they don't want to rent to, if elderly Mrs. Murphy doesn't want to rent to a 19-year-old, actually that person wouldn't be protected anyway because of that age definition. But if she didn't want to rent to a family with children, as long as she doesn't say it, yeah. And then in situations, and this is kind of the Facebook issue that came up recently, is both the advertiser, so if it's a newspaper, if it's Facebook, can also be held liable for discrimination, as well as the individual who placed the discriminatory ad. And so some of the factors in determining when advertising is discriminatory is things like references to neighborhoods or religious institutions that may have some loaded connotations as far as things like national origin or religion can be considered to be discriminatory. Things like where advertising is distributed, if somebody's only targeting a particular protected class with their advertising, that can be considered a violation as well, even if that's not stated in the advertising itself.
But 55 and older communities,
That's okay. That's okay. And usually, what they should do, they should say that. They should say this is a 55 and older community. We see a lot of, active adult is pretty ubiquitous. There have been instances where, in addition to their conduct in who they're permitting to rent there, that's been found to be part of a pattern of discriminating against people with disabilities because they're looking for kind of a younger, more able-bodied retiree, and that active adult language has been found to be part of that pattern of discriminating against people with disabilities. Okay. So a little more detail on families with children. So only senior housing that meets that housing for older persons definition can restrict families with children, or Mrs. Murphy if she meets that exemption. We see some additional rules and conduct that is considered discriminatory in addition to just outright refusal to rent to families with children. So we've seen a lot of buildings where, it's an apartment building or an apartment complex where there's a kids building and an adults building, where they're segregating the housing based on familial status. Also rules like only allowing children on the first floor and not on the upper floors would be considered fair housing violations against families with children. And then kind of a whole category of kind of safety and health rules that landlords sometimes have, things like restricting children because of unsafe conditions, saying, you can't rent this housing because there's a balcony and that's not safe for children. Rules that say boys and girls can't share a bedroom, or parents and children can't share a bedroom. that these types of rules are always the parent's decision to make, and that even though parents may have ideas about the safety of a unit for their children, or may want to, if they have a son and a daughter, be in a 3-bedroom as opposed to a 2-bedroom, that's never a permitted decision for a landlord to make on behalf of a family. And yes.
So then if a landlord, though, if they can't say they don't feel it's safe and they're not able or willing to make modifications, can they make them sign some sort of disclaimer as part of the lease?
Well, that's a situation where it's important to remember that the Fair Housing Act wants you to treat everybody equally. So if there are types of potential hazards, that's something that a landlord should address with everybody. If there is a balcony, they should point out that feature to everyone, not just the family with children. So, the Fair Housing Act doesn't prevent a landlord from doing what they feel they need to do to address. Obviously we want to see landlords addressing hazards that may be in their units.
Yeah, but it's not always a hazard, but, we have townhouses, and I know where I live, I mean, you have the balcony around the deck.
Right.
Railing around the deck. Well, 2 doors down, the neighbor's kids are like dangling over
Right.
the.
Right.
You're not supposed to do that, that's the parent.
Yeah.
And if something would happen, if it was a tenant, they would always point out, well, you
Right.
should have made it safe.
Right.
And
Right.
I get
Right.
where you're coming from. You can do that, but you have to do it with
Yeah.
everyone.
Yeah.
Regardless,
Yeah.
just put that disclaimer in there.
Exactly. And it's interestingly, with some of these, we get complaints from consumers who try to invent ordinances that they say that their township has when they don't actually. We've had a lot of prospective tenants call us and say, the landlord says that it's a township regulation about something like occupancy, and then we check with the township because it doesn't sound, like a typical ordinance that a township has, and the landlord has just invented township ordinances that it's using to deny people with children that don't actually exist. So yeah, we do see that. I'm sure they call you as well. Then again, terms and conditions applies to families with children. So charging higher rent or security deposit to families with children. Rules and regulations. I think that got a little into your safety, the safety issue. Things like pool facilities that apartment complexes will pass rules that apply just to children rather than something more universal, like swimming tests for anybody who's going to use particular sections of the facilities. Per capita charges are usually discriminatory. There's some very limited circumstances where if a landlord can truly document that each additional person is going to use an extra $10 of water a month, and the landlord pays for the water, that can be acceptable. I don't know why a landlord would do that rather than just raise everybody's rent $20 to kind of average that out. But per capita charges are a little bit dangerous for a landlord to implement because they have to be so specifically justified in order for that to not be considered.
Can a landlord, when they sign a lease saying you're renting to an individual, I know of a case where one person rents an apartment.
Right.
Next thing you know, a friend moves in, and
Right.
another friend moves in, and it's
Right, right.
One rental turns into 6 people.
Yes, yes. Again, they can enact procedures around that, around how they deal with that, as long as it's not singling out one group of people over another. And we'll talk about, when we talk about zoning, the definition of family in zoning ordinances, which is acceptable but is sometimes implemented in a discriminatory way, and how to avoid that. Okay, just a couple notes on religious discrimination. We see a lot, especially with senior housing, that it is operated by some sort of religious institution, and it's acceptable for, a religious organization that operates housing to retain that religious language in their name, Baptist home, Presbyterian senior housing, whatever, Saint whomever's nursing home is fine if they retain that language in their name, but it should be accompanied by an equal housing opportunity disclaimer that they are offering housing to anybody regardless of religion. And then any type of housing that contains HUD funding, the government just obviously requires that housing services that are government funded be offered separate from any type of religious services or activities, and that the religious services that are offered be not a condition of receiving housing. All right, national origin and immigration status, and we'll talk a little bit more later on about this in the context of municipal ordinances. But basically, the Fair Housing Act doesn't care about immigration status. Anybody is entitled to protections under the Fair Housing Act regardless of their immigration status, and based on any protected class, whether it be national origin, whether it be familial status. So I'm going to go off a little, off message a little bit. In the past, it's been HUD's practice not to ask about immigration status when individual consumers file fair housing complaints. Right now, I'm not necessarily advising anybody who is a caseworker for an undocumented person or an undocumented individual to file a complaint, because our government's rules about how around immigration and about immigration enforcement are in flux. So it is also illegal under that category of coercement, intimidation, and threats to include among that type of intimidation threats to report somebody's immigration status. So we've had these situations of landlords. We had a case where there was a landlord who was particularly recruiting Mexican immigrants to live in their apartments. Some documented, some undocumented, a variety of immigration statuses. And then they had rules that violated the Fair Housing Act based on familial status. So they were particularly targeting this population to move into their building, but then they would say, oh, I see that you're pregnant. You have to pay me $500. Your kid rode their bike across the grass. you've got to pay me $200. That the landlord was sort of recruiting people that they thought that they could exploit, fining them for all these things that were violations of the Fair Housing Act. And then if anybody pushed back saying, well, you know, I'm gonna report you for immigration enforcement. So that's the example of the type of thing that we tend to see. Housing providers are allowed, again, to request documentation regarding identity, regarding qualification to rent or buy particular housing, but it has to be a consistent procedure. They have to request the same documentation of anyone across the board, whoever applies. So any questions on that? All right, I'm going to go into disability. As I said, this is an area where some of the requirements get a little bit more complicated. We have the popular assistance animal issue and the whole area of reasonable accommodations and modifications. So under the Fair Housing Act, disability is defined as any type of physical or mental impairment that affects a person's ability to conduct major life activities. Additionally, the Fair Housing Act includes people who have a history of an impairment. So a good example of that would be addiction. You know, somebody who's in recovery from an addiction, not currently impaired in their life activities because of that history, but because of the history of addiction is still protected under the Fair Housing Act. And also people who are perceived as having an impairment. So an example of that would be somebody who is HIV positive. Their status might not affect any of their major life activities, but may be perceived by housing providers to be an impairment. So disability issues are a little broader than some of the other protected classes, than race or familial status. You know, we have the same types of issues about different treatment being prohibited, steering, harassment, all same goes for disability as with any of the other protected classes. Inquiries into the nature and or extent of a disability are always illegal under the Fair Housing Act. So basically, whether it be a municipal government or whether it be a landlord or any other type of housing provider, providers are never going to be permitted to ask questions that would get at private medical information.
Can we go into the hoarding thing then?
Yes.
Because we get a lot of these complaints and we get a lot of rental units.
Okay.
And when somebody, you know, they walk into, what the normal person would obviously determine to be a hoarding situation.
Right.
And I know that hoarding has been determined to be a disability.
Right.
But how do you say either you're just a messy person or you're
Yes.
a hoarder?
Yes.
And how do you get that?
Okay, so the question was about dealing with a hoarding situation and the prohibition into inquiring to the nature and extent of this disability. Let's get to reasonable accommodations, and I'll use that as an example of, you know, how you should deal with reasonable accommodations in that situation. So basically, a reasonable accommodation and modification requests are, I'm going to say 50% of our work with consumers is helping with negotiating these types of requests. In our office, well over half the complaints we receive are based on disability as opposed to the other protected classes. And of those, the majority are this issue of reasonable accommodations and modifications, because it's really fact specific. It depends on the particular consumer and their needs and the provider, their size, the configuration of their units, and it can be really extremely case by case. So a reasonable accommodation is basically a change in rules, policies, practices, or services that enables a person with a disability equal opportunity to use and enjoy a building, or use and enjoy a dwelling. So really easy examples of this is like a reserved parking space for somebody with a mobility disability. Things like transfers to more accessible units for somebody who becomes disabled when they're living in a unit. Lease applications in large print, or reading content to somebody who has visible disability, vision disabilities. I'll talk about assistance animals separately, because that's always another tricky situation. And then a reasonable modification is a change in the physical structure of a dwelling. So something like a ramp is an obvious example, grab bars in the bathroom. And who pays for these types of modifications varies depending on the type of housing. If there's some type of subsidy involved, typically the housing provider is going to be required to bear the cost of accessibility modifications. If it's private housing, a private landlord with no subsidy involved, the tenant is responsible to bear the cost of the modifications, but the landlord has to allow them to make those modifications. So let's just talk through, on the next couple of slides, your example of hoarding. So the number one issue that I think gets a little bit at what you're asking is a housing provider is not ever obligated, and nor should they ask if somebody requires a reasonable accommodation. That is not a burden that's on a landlord or housing provider to say, do you need an accommodation, or to offer an accommodation. It's always the consumer's responsibility to request an accommodation. So in a situation where there's some sort of code violation due to hoarding, you wouldn't be responsible to offer a reasonable modification or a reasonable accommodation. And that, when a housing provider offers a reasonable accommodation, that can get into making assumptions about somebody's disability, possibly getting into asking if they have a disability, which is you don't want to go any of there. So it's always the consumer's responsibility to ask. They don't have to ask in any particular type of format. So verbal requests are considered a reasonable accommodation. Written requests, we always recommend a consumer make a written request, just, for them to document the process, but always the consumer whose responsibility to make the accommodation. So you go into a situation, a hoarding situation, that rises to the level of a code violation. You can go ahead and go through whatever your process is. But if that person requests a reasonable accommodation, or is working with some other type of caseworker or some type of support person who asks for a reasonable accommodation, that would trigger this process. And we get complaints, or we get calls from people who are in that situation, who have received some sort of initiation of code enforcement by a municipality. And we'll inform them, you have the right in this situation. They don't have to offer it. You're the one who has to ask if you can have a reasonable accommodation for, more time to clean up. time to put support services or some type of assistance in place to mitigate this, this risk that has been created by your disability. So, I would advise kind of general education of your residents about their fair housing rights in general, but I wouldn't necessarily advise, going to an individual resident and saying, do you need a reasonable accommodation? Because that's not your responsibility. And, in that case, trying to do the right thing could lead you to, a fair housing concern on the part of that resident who then feels like you've made inquiries about their disability. Mm-hmm.
Yeah, I agree that it's not the owner's responsibility to ask for if a person needs a reasonable accommodation, but
Mm-hmm.
I think one of the big issues is where there's a conflict between tenants. I mean,
Yes. Yes.
My office has represented a nonprofit owner of residential housing. We had a situation where an elderly high-rise was not in Lehigh County, but they had a no pet policy, and one individual is asking for permission for a cat as a comfort animal, and we suggested to the owner that yes, that should be allowed, but then the neighbor says, I'm allergic to cats.
Yep.
And we were in contact with HUD as to how you evaluate these conflicting claims. But you're really put in the situation there where, in evaluating whether it's going to cause harm or damage to others, where you almost have to make an inquiry as to the nature of the disability, because the person who said that their cat, or that they had these cat allergies, and these were elderly individuals, and they're older children who were concerned, and the doctor submits a letter saying she's allergic, but we had to say, well, can you give us any, can you be more specific so that we could evaluate that? And it wasn't possible to move the residents to different areas because the building was full.
Yeah, so the competing disabilities are one of the most difficult issues. We have a really similar one in our office now, where we've received, a request from the landlord on how to work this out, and a complaint from one of the tenants about the landlord, where it's like one apartment, it's an elderly woman who's hard of hearing, who listens to her TV really loud. The other one is a family with, like a mom with an adult daughter with autism who has like sensory issues, and these two competing disabilities, both being really set off by the other one. And it's interesting that case that you bring up, the assistance animal and allergies, is another really common one where HUD is looking to see, and there have been a number of cases about that the same verifications are being asked of both individuals. And I'll talk about verifications and what you can and can't ask, and in what situations. But there was a case, actually. It was in a college dormitory. It was somebody asked for a support animal, somebody else said they were allergic, and it turned out that the university asked for verification from the person who needed the assistance animal, but not the person with the allergies. And so it was like a disparity in how those two cases, the two individuals were handled. But it's really difficult, and this is, the challenge of requiring an interactive process. Sometimes when the landlord is really trying to do the right thing by these people, and they're not, they're not willing to come to any type of resolution. And in that kind of situation, the only advice I have for a housing provider is to just keep documenting everything that you're doing to resolve, because you want to be able to prove, if necessary, that you've fulfilled your obligation to try to make a reasonable accommodation, try to provide a process for the tenants. But those are really, really, really difficult.
Well, as a landlord, can't you just say no pets, period?
You can say no pets, but for somebody who does need an assistance animal, that would be a situation where you'd be required to make a reasonable accommodation to that rule.
Well, if you own the property and you don't want pets in your property, I mean, you know, any pet, whether it's a assistance animal or whatever. And I know situations where people have, you know, pigs or small horses as their support animals. I mean, that's bizarre. The fact that if you're a landlord, then why should you allow them on your property? Period.
Right. Well, I mean, I'm just the messenger. I didn't create this law, so I mean, I can tell you that there's lots of case law that requires landlords to make this accommodation. I'm going to talk about what's reasonable, so we can talk about what might be reasonable and unreasonable in terms of an animal, and I'll talk about verifications, how you're allowed to verify that there really is a disability and there's a need for that disability.
What does HUD look at as a distinction between ADA compliant and support animals? There's
Right.
very
So the ADA,
distinct differences.
the ADA requires certification and training of it. So if you want to bring your dog into a restaurant, it needs to be a certified, trained service animal. The Fair Housing Act is more broad. The theory being that somebody's entitled to more, more rights in their own home than they are in the restaurant, on the plane, whatever. So assistance animals under the Fair Housing Act do not have to have specific training or certifications. So
my pet cobra, which is my support animal, is permitted.
right, we'll talk about your pet. We'll talk about your pet cobra. Did you have a question before I get kind of?
Yeah, it had to do with certification, so you kind of touched on it already.
Okay.
But the secondary question would be, situation that, okay, it is a support animal, Rottweiler, Doberman, what have you, pit bull.
Right.
4-unit apartment building, and now we have small children in the building,
Mhm.
and personally, my insurance will not cover those animals
Right.
in my building. Am I allowed to charge the tenant to have insurance that would then cover me as an additional insured on a primary non-contributory basis?
So a couple thoughts about that. I don't have the exact answer to the question that you're asking. One is that there is guidance around the issue of the landlord's insurance. So there are insurance companies that do have breed restrictions. So if a landlord is going to deny a reasonable accommodation request for an assistance animal that's covered by that breed restriction, they need to prove that they, obviously that restriction exists in their insurance policy, but they also have to demonstrate that they couldn't acquire insurance that didn't have that restriction at a similar cost. So there has to be some demonstration, if you're going to deny that request, that you attempted to look for insurance that didn't have the restriction and couldn't acquire that at the similar cost to your current insurance. And we can talk later and I can direct you to where to find that guidance. The other thing about requiring insurance for tenants is I think that's, it may be an area where it makes sense to require that your tenants have renter insurance, and then in the process of gaining that insurance, the issue of animals will be addressed, and they'll have to, that's an across-the-board requirement that really protects you, protects all of them, and doesn't single somebody out based on the assistance animal issue. All right, so I'm going to talk about what's reasonable. Obviously, in talking about cobras and ponies and all sorts of things, that the obvious question is, when does HUD or a court potentially consider a reasonable accommodation request to be reasonable or not reasonable? So there's a four factor criteria for whether a request is reasonable or not. So first, it can't cause an undue financial and administrative burden to the housing provider. This is variable, obviously, depending on whether somebody is a huge, thousands of unit property manager or mom and pop landlord who own 10 units. This is going to be an area where it's case specific. What's an undue financial administrative burden is going to vary from provider to provider. It can't cause a basic change to the nature of the housing program available. And the example that I always use for this is somebody who has a mobility impairment, goes to their landlord, says, I have a hard time leaving my apartment. I would like you to do my grocery shopping for me. I'll give you the money. You just deliver my groceries. That's not what that landlord is offering. The landlord is offering housing. That would be a change to the basic nature of the housing program available. It can't cause harm or damage to others. I think that could be an area where the extreme animal examples that people sometimes suggest could certainly fall under this policy. My last group asked about a support giraffe, and this is obviously a combination of damage and technologically possible. So it also has to be technologically possible. If somebody's requesting a ramp up to the third floor, kind of wrapping around the building, that's not going to be a reasonable accommodation or modification. Assistance animals. So assistance animals, as we said, this does differ from the ADA in that animals that are not necessarily trained and certified can be legitimate assistance animal requests, and that they fall under the same category of denial of making reasonable accommodations, that when reasonable, that the housing provider has the responsibility to allow them. In that case, it's not, yes.
Difference between, because I know under the federal law, a service animal has to provide a service. So is there a definition of an assistant animal versus the service animal?
Right. So the question was about the definition of a service animal versus an assistance animal. An assistance animal, my understanding is that's kind of a catch-all for any type of assistance animal. So it could include a service animal that is specific, a guide dog that has specific training and certification. Or it could include something like an emotional support animal for somebody with maybe like a mental health disability or some other type of disability. Okay, I'll get to verifications.
I have
Yes.
a service dog.
Mm-hmm.
It's not considered an assistance animal. I mean, I take it to Fellowship Manor
Mm-hmm.
and let the people pet it and that
Right,
kind of stuff.
right.
She's not considered, I can't take her in the restaurants and things like that.
Right, right.
She's not certified for that.
So that would probably be a really good example of, under the state law, the trainers or handlers of assistance animals, that's like a therapy dog.
Yeah, she's
Right.
She's licensed. She's
Mhm.
has a therapy license.
Mhm.
All the credentials, but she can't do like a guide dog or something
Right.
like that. She's not allowed
Right.
in those particular instances.
Right.
Only certain instances can I take a therapy dog into.
Mm-hmm.
Well, if I wanted to bring her in here and have everybody pet her, that's okay.
Right,
But I
right.
can't take her in and I say,
Right.
"Sit here,
Right,
and I'll give you a hammer."
right,
Not the way it works.
right. And again, you know, in a Fair Housing Act case, this is where it differs from the ADA, that the ADA requires the certification, the license, the Fair Housing Act does not. Okay, so as far as verifying disability and need, this is, you know, how do you get to the, you know, how do you get to whether a request for a reasonable accommodation is actually necessary? And, you know, a lot of providers ask, you know, can I just make a blanket across the board policy for this? And this is an area where the Fair Housing Act is really clear that there are certain times that you can ask for verification and there are not. There are other times when you're not permitted. So basically, if the disability is obvious, and I'm going to go with the dog example here, and the need for the accommodation is also obvious. So if somebody comes in and is obviously blind, you can tell that they're blind and they have a guide dog. That's a situation where a housing provider is not permitted to ask for additional information because it is, you know, it is obvious to the observer that both the disability and the need for the accommodation. So if the disability is obvious, but the need for the accommodation is not obvious, that, you know, somebody comes in, they're a wheelchair user, they're using a wheelchair, and they have a dog. You can see that that person has a mobility impairment, so you can ask for, but you don't know what you know, the dog provides to them. Maybe the dog retrieves objects or whatever. You don't know. You can only ask for verification of the need for the accommodation. And then if both the disability and the need are not known, you can ask for verification for both. So say somebody comes in, they don't look, you know, to your observation to be disabled, they ask for an accommodation for an assistance dog, which is also not obvious. I mean, maybe it's somebody who has epilepsy and they have a seizure detection dog. You know, that's a case that we've dealt with in our office. But in that case, you would be able to request a verification. And as far as verifications should be from some type of professional that's familiar with that person who has some type of treatment-related relationship to them. You know, the trend is now the online certifications. I don't know if any of you have seen those. I did one of these. I went on the internet. I went to one of these emotional support animal certification sites. There was like a 10-question survey, and it was things like, you know, have you had trouble falling asleep anytime in the last month? I'm like, oh yeah, sure. You know, have you ever felt nervous or worried about anything in the last month? Of course. You know, went through the survey, and they said, you know, your individual therapist consultation is standing by. You know, pay your $185 and then call in to this person and we'll issue you a certification for an assistance animal. That is not, you know, as a housing provider, you don't, those are just scams. It really needs to be an individual letter from somebody with a familiarity with that individual. And it needs to say, it doesn't need to tell the nature of the person's disability, you know, nothing that's confidential information or sensitive information, but it does say they have to verify that the person does fall under the Fair Housing Act definition of disability, and that the accommodation that they're requesting is necessary to ameliorate whatever the the effects of their disability are. And we have, and I didn't bring them, but we have kind of a guide for medical professionals now, because this, we've had a lot of issues with complainants calling us saying they've gotten verification from their doctor, and it's a pretty weak verification. It'll say something like, I feel like this animal would be beneficial for them. That's not really strong enough. That's not really a case where that's going to be found to have been necessary for that person to use and enjoy their dwelling. And so we've really been trying to provide some education to both consumers and medical providers on what is a sufficient verification, because we've seen so many of them that are, we have people call us all the time with really legitimate requests, but also people who are like, I have a dog and I have a disability. They don't have anything to do with each other, but how can I get my landlord to allow this? Yes?
So you live in Whitehall Township and you have an animal that you want to keep that's not considered a household pet.
Mm-hmm.
I send you a notice that you can't have that, and you come back with something like that.
Right.
Even though the law says you can't have that animal, that letter from your doctor is going to trump it.
Right. It's going to depend. It's going to depend on whether it's reasonable under those points. But any ordinance is going to be a situation where a reasonable accommodation will need to be made if it's reasonable, and if it's
You live in an apartment and you have a pet pig, which is not
right.
permitted.
Well, that's
But then you come back with that notice or a letter from your doctor.
right. So the pig issue is arguably going to be a destruction of property type of issue. That depending on the individual's circumstance, having a pig in an apartment is going to fall under harm or damage to the property.
If they come to me with a letter saying that they need it for emotional support.
Right.